Hello everyone. Today's topic is Rights in the Indian Constitution. Fundamental rights are inspired by the Bill of Rights included under the French Constitution. Indian Constitution under part 3 includes a vast list of rights. These are the basic rights and are justiciable. They run from Article number 12 to 34 and include 6 broad categories of rights. The difference between fundamental and ordinary rights are: fundamental rights are protected and guaranteed by the Indian Constitution. On the other hand, ordinary rights are protected and enforced by ordinary law. Fundamental rights can only be changed by amending the Constitution of India itself. On the other hand, ordinary rights can be changed by the legislature by ordinary process of law making. Now we come to another topic, that is category of fundamental rights. We have 6 broad categories of fundamental rights in the Indian Constitution. The first fundamental right, equality, which runs from Article number 14 to Article number 18. Article number 14, equality before law and equal protection by the law. Article number 15, prohibition of discrimination. Article of opportunity. Article number 17, abolition of untouchability. Article number 18, abolition of titles. The limitation of Article number 14 is certain special privileges are assigned for offices like president, governor, etc. The limitation of Article number 15 is the state can provide for protective discrimination. The limitation 16 is Parliament may make laws restricting equality of opportunity, example, reservation policy. The limitation of Article number 18 is certain military and socio-cultural rights titles have been retained, like master, brigadier, etc. The second fundamental right is right to freedom, which runs from Article number 19 to Article number 22. Article number 19, civic liberties. Article number 20, rights of an accused person. Article number 21, protection of rights and personal liberties. Article number 22, protection against arbitrary detention of a person. The limitation of Article number 22 is that it can be limited under Preventive Detention Act. The third fundamental right is exploitation, which runs from Article number 23 to Article number 24. Article number 23, prohibition of begar or forced labor. Article number 24, prohibition of employment of children below age of 14 anywhere. The fourth fundamental right is right to freedom of religion, which runs from Article number 25 to Article number 28. Article 25, free to practice and propagate religion of one's choice. It can be limited on the grounds of public health, order and decency. Article number 26, right to establish and maintain religious and charitable institutions, manage its affairs and properties. Article number 27, freedom to pay taxes. Article number 28, freedom to attend religious instructions. The fifth fundamental right is cultural and educational rights, which runs from Article number 29 to Article number 30. Article number 29, protection of language and culture of minorities. Article number 30, right of minorities to establish educational institution for the purpose. The sixth fundamental right is right to constitutional remedies. It involves the right to our Supreme Court. The court issues special orders known as writs for enforcement of rights. The limitation of this article is it can be suspended during times of national emergency. The sixth fundamental right, that is right to constitutional remedies, has been called as the soul and very heart of the Constitution by the architect of Indian Constitution, B.R. Ambedkar. This right is also known as the watchdog of the Constitution and democracy itself. We come to another topic, that is writs. The Supreme Court and the High Courts issue special orders for enforcement of fundamental rights. These orders are known as writs. Types of writs are habeas corpus, to have the body of. A writ of habeas corpus means that the court orders for the arrested person to be presented before it. If the manner and ground of arrest are not lawful or satisfactory, the arrested person can be set free. 2. Mandamus, we command. It is issued when the court finds that a particular office holder is not doing legal duty, thereby violating fundamental rights of an individual. Number 3, prohibition. It is issued by a higher court when a lower court has considered a case going beyond its jurisdiction. Number 4, quo warranto. By what authority? If the court finds that a person is holding office but is not entitled to hold that office, it issues a writ of quo warranto to restrict that person from acting as an office holder. Number 5, certiorari, to be fully informed of. The court orders a lower court or another authority to transfer a matter pending before it to the higher courts. We come to another topic, that is directive principles of state policy. Directive principles of state policy are some guidelines that are not legally enforceable. Governments are expected to implement them while making laws. From time to time, governments have tried to implement them. For example, nationalization of banks, Minimum Wages Act, etc. They were directed towards equality and justice. The main policies of directive principle are equal pay for equal work for both men and women, right against economic exploitation, right to work, promotion of cottage industries, promotion of village panchayat, prohibition of consumption of liquor, prevention of slaughter of useful cattle, promotion of international peace, equitable distribution of resources in the society. we One very important thing that we need to know is the difference between fundamental rights and the directive principles of state policy. The fundamental rights are ordinary citizens, while on the other hand, directive principles are directions given to the governments. Fundamental rights are negative in nature, whereas directive principles are positive commands to the governments. Fundamental rights are specific and detailed, while on the other hand, directive principles of state policy are general in nature. Fundamental rights include a number of limitations, while directive principles have no limitations involved. Fundamental rights establish political democracy. Principles try to establish socio-economic democracy. Fundamental rights are justiciable, while directive principles are non-justiciable. And this becomes the major difference between fundamental rights and the directive principles of state policy. With summing up all these things, we have ended with the chapter and the topic, and I hope all of you have enjoyed the lesson and the topic and have grasped everything fully and smoothly. I hope you all had a happy learning. Thank you.